Hello and welcome to Unacademy. Mr. Raghav Chadha and 6 other Rajya Sabha MPs belonging to the Aam Aadmi Party have resigned and joined the BJP. Mr. Raghav Chadha claims that they are invoking the provisions of the Constitution and merging with the BJP. Which is that provision of Indian Constitution? 10th schedule or Anti-Defection Law? Now the question is, will these MPs, even after they have merged with the BJP, be disqualified under the same anti-defection law? There are two things, and listen to me carefully. Question number one, should these MPs be disqualified? Question number two, will these MPs be disqualified? Should these MPs be disqualified? Yes. According to the same anti-defection law, all these Rajya Sabha MPs who have merged with the BJP should be disqualified according to the Constitution. But will they be disqualified? No. Why? Because according to the same provision of the Indian Constitution, anti-defection law, who has the power to disqualify Mr. Raghav Chadha and 6 other Rajya Sabha MPs? The chairperson of the Rajya Sabha. And who is that chairperson? The Vice President of India. And you would know that the Vice President of India was previously part of the BJP. And these Rajya Sabha MPs have joined the BJP. So why will the Vice President of India disqualify these MPs? But should he? Yes. This is political news. And on this channel, we extract polity concepts from political news. And that's precisely what I'm going to do today in this particular video. We'll discuss the fascinating provisions of anti-defection law, important Supreme Court judgments as well. So this is your one-stop destination to understand this issue in great detail, strictly according to the requirements of the Civil Services Examination. And if you are preparing for the Civil Services Examination and you are attempting this exam in 2027 or beyond, now is the best time for you to enroll in our UPSC preparation programs. For GS, CSAT, current affairs, answer writing, mock tests, mains test series, all these features are available in Unacademy Plus, which right now is available at 16,999. Go to our website, and while making the payment, you need to apply this code IAS English should you wish to enroll with us at this 16,999 offer. Let's come back to the topic. Which is that provision of the Indian Constitution cited by Mr. Raghav Chadha, 10th schedule or anti-defection law? Listen to me carefully. What does this law say? Provision number 1. Whosoever voluntarily gives up the membership of a political party will be disqualified. So if you are a member of a house, Mr. Raghav Chadha and 6 other Rajya Sabha MPs, they were the members of the house, the Rajya Sabha, belonging to which political party? Aam Aadmi Party. They will be disqualified if they have voluntarily given up the membership of this political party. So according to this provision, Rajya Sabha MPs, Mr. Raghav Chadha and 6 others belonging to Aam Aadmi Party, since they have voluntarily given up the membership of their party, they will be disqualified. But what they have cleverly done is used another provision of the Constitution. Now listen to me carefully. When Mr. Vajpayee was the Prime Minister, this provision was amended. Till that time, if 1/3 of your legislators they resign from your party and join another political party, they will not be disqualified. But after 2003, when this amendment was made, even if 1/3 MPs belonging to your political party, they resign from your party and join another political party, they will be disqualified. But then there is one provision. Disqualification on ground of defection will not apply in case of a merger. And that's precisely what Mr. Raghav Chadha and other MPs have done. They have claimed that since Aam Aadmi Party had 10 MPs in the Rajya Sabha, 7 MPs, which amounts to 2/3, they have decided to merge with the BJP. And when you merge with another political party, you will not be disqualified under anti-defection law. But this is a mischievous reading of this law. according to the spirit of the law, these two-third MPs deserve to be disqualified. Now, please listen to me carefully. I am not the supporter of the Aam Aadmi Party. I don't even like Mr. Kejriwal, but I want to speak facts related to the Constitution. Nothing more, nothing less. The point is, when do political parties merge? Listen to me carefully. If Aam Aadmi Party had decided to merge with the BJP, so political parties, they decide to merge with each other, then will this merger be acceptable to the legislators of that political party? That's the key question addressed in this provision. Constitution says if these two political parties merge, that means now there won't be Aam Aadmi Party, there would only be the BJP. What will happen to the legislators of the Aam Aadmi Party? They will also be part of the BJP. But these legislators should accept the merger. And what is that percentage? 2/3. Only if these two political parties merge with each other and this merger is supported by 2/3 of the legislators, then these legislators will not be disqualified. What will happen to those 1/3 who do not accept this merger? They will be treated as a separate group. So long story short, ideally, according to the spirit of Anti-Defection Law, Mr. Raghav Chadha and 6 other MPs would have been saved from disqualification under Anti-Defection Law provided Aam Aadmi Party and the BJP merge with each other. But Aam Aadmi Party has not decided to merge because that decision will be taken by the leadership of the political party. And the leadership of the political party is not with the legislators. That is exactly what the Supreme Court has said in the famous Shiv Sena case. There is a difference between a legislature group, legislature wing of a political party, and the organization wing of a political party. Who is the convener of the party or the president of the party? Who are the office bearers? They have to decide about the merger. But this is a law which has been often misused by political parties, whether it is Congress or the BJP or any other political party. Naturally, what will happen? This matter will go to the court. And once the court will hear this matter, then we will have a final verdict as to whether this provision, which is being misused like this, whether this provision needs to be interpreted according to the spirit of the law. So long story short, if Mr. Raghav Chadha individually would have joined the BJP, he would have been disqualified. Now what he and others have done, they have decided to misuse this provision, which is 2/3 provision, which is disqualification will not apply in case there is a merger. But that merger has to be supported by 2/3 of the legislators. Now something else. When this law was passed in the year 1985, 52nd Constitutional Amendment Act added 10th schedule to the Indian Constitution. This 10th schedule gave the power to the Speaker to decide on these matters of disqualification. Speaker of Lok Sabha, Legislative Assembly, Chairperson of the Rajya Sabha and the Legislative Council. Since we are talking about Rajya Sabha, that means this power is with the Chairperson of the Rajya Sabha, the Vice President of India. Originally, when this provision was inserted into the Constitution said the decision of the Speaker shall be final and binding. Matter went to the court. Kihoto, Hollohan versus Zachilhu and others in 1992. The Constitution bench of the Supreme Court said decision will be taken by the Speaker or the Chairperson, but that doesn't mean their decision shall be final. Because who has the power to take the final decision? Judiciary, because judicial review is part of the basic structure of the Indian Constitution. That's another important matter. But now listen to me carefully. Ideally, who can complain to the chairperson that these MPs have defected from our political party and as such should be disqualified? An interesting thing happened way back in 2013 in Orissa. There were 4 MLAs belonging to the NCP. All these NCP MLAs joined the BJD of Mr. Biju Patnaik. According to the rules as they existed at that time, legislator could have complained to the Speaker. That means an MLA of the Odisha Legislative Assembly could have complained to the speaker that these MLAs, they have defected and as such should be disqualified under Anti-Defection Law. Only a sitting legislator can complain. But there were 4 NCP MLAs who joined the BJD, so there was no NCP MLA left. The then president of the NCP in Odisha approached the court and said, "My lord, we approached the speaker that please take action against these 4 MLAs and they should be disqualified." But the speaker said, according to the rules, only a legislator can complain. But we don't have a legislator in Odisha Legislative Assembly. The Supreme Court said, no. Voters have locus standi. Any voter can complain. Any person can complain. So you don't have to be necessarily the member of a legislature in order to file a complaint before the speaker that this MLA should be disqualified. Which means any voter can complain to the chairperson of the Rajya Sabha that these MPs belonging to previously the Aam Aadmi Party and now the BJP be disqualified. Anybody can complain. But what could have been the other option for Mr. Kejriwal or Aam Aadmi Party? Mr. Kejriwal and his Aam Aadmi Party could have expelled Mr. Raghav Chadha and others. But if you would have expelled Raghav Chadha and others, even then they would not have been disqualified. Why? Because that is the loophole in the law. The law is silent on this particular matter. The law says if you defect, if you join another political party, you will be disqualified. If you violate the whip issued by the political party, you will be disqualified. But what will happen in case you are expelled by the political party? The law is silent on this matter. And that is how people approach the courts. Vinod Kumar Binni, who was part of the Aam Aadmi Party when elections happened in Delhi in 2013, he was expelled by Aam Aadmi Party and then he approached the Supreme Court and Supreme Court said, you are now treated as an independent. That means you will now be an independent MLA of the Delhi Legislative Assembly. But now the point is, if Raghav Chadha and others would have been expelled, they could have been declared as independent members of the Rajya Sabha and then the whip of the Aam Aadmi Party would not have been binding on them. That is why he was not expelled or others were not expelled. But there was another option. Mr. Kejriwal and his Aam Aadmi Party could have approached the Rajya Sabha chairperson that please disqualify Raghav Chadha and others. Despite the fact that Mr. Raghav Chadha has not joined the BJP. Despite the fact that Mr. Raghav Chadha has not voluntarily resigned from the Aam Aadmi Party, even then he could have been disqualified. Why? Because the Supreme Court said in 3 important cases, Ravi Nayak, G. Vishwanathan, Sri Rajendra Singh Rana and others versus Swami Prasad Maurya and others, you don't have to necessarily submit a formal resignation letter in order to get disqualified under Anti-Defection Law. So even if Mr. Raghav Chadha has not resigned from the Aam Aadmi Party, even then he could have been disqualified. Why? We have to look at his conduct outside the house. If Raghav Chadha is not participating in the meetings of the Aam Aadmi Party, is violating the discipline of the Aam Aadmi Party, is attending the rallies and the meetings of the opposition political parties, we could have assumed that Mr. Raghav Chadha has voluntarily given up the membership of his political party and as such, he should have been disqualified. But then, Aam Aadmi Party or Mr. Kejriwal had to approach the Vice President of India to disqualify Raghav Chadha, which the Vice President would not have done because the BJP Aam Aadmi Party rivalry. But now, something interesting. Is this case similar to what we saw in Maharashtra? No, slightly different. In Maharashtra, there was a split in Shiv Sena. One camp led by Uddhav Thackeray, another camp led by Eknath Shinde. But Mr. Eknath Shinde's camp, they did not say we merge with the BJP. They said we are the real Shiv Sena. Similarly, Ajit Pawar, he split the political party, the NCP. But he did not claim that we are merging with the BJP. He said we are the real NCP. In this case, the role of the Election Commission of India becomes important Because Election Commission of India has the power to decide that in case there is a split in a political party, who will get the name of the political party, who will get the symbol of that political party. But how does Election Commission of India decide this? Election Commission of India performs a test. Test as to who has the majority in the organization and who has the majority in the legislature. Sir, what does that mean? Long story short, Election Commission of India will look at, this is Aam Aadmi Party and this is the organization of the Aam Aadmi Party, the convener, the presidents, others, office bearers of the Aam Aadmi Party. And in this office structure, organizational structure, who has the majority? Do the majority of the office bearers support Mr. Kejriwal or Mr. Raghav Chadha? And then it will be decided on the basis of the legislature wing. Aam Aadmi Party has 10 MPs in the Rajya Sabha, but 3 MPs in the Lok Sabha. What if 3 MPs of the Lok Sabha say, no, we support Arvind Kejriwal? What if majority in the Rajya Sabha say, no, we support Raghav Chadha? In that case, we cannot decide on the basis of the strength in the legislature wing. Then we have to decide on the basis of the strength in the organization. And this is where maybe Arvind Kejriwal has the majority. And then ECI would have been constrained to decide that no, it is the Arvind Kejriwal's group, which is the real Aam Aadmi Party. And the name and the broom symbol will be retained by Arvind Kejriwal. By that logic, Raghav Chadha and others would have been disqualified under Anti-Defection Law. That is why they did not take the route of saying, we are the real Aam Aadmi Party. They cleverly said, we are invoking the provisions of the constitution. We are merging with the BJP because 2/3 of the Rajya Sabha MPs have decided to merge with the BJP. Loophole, but we will have to see how it will fare in the courts. Long story short, when we look at Anti-Defection Law, 52nd Constitutional Amendment Act introduced 10th schedule to the Indian Constitution, provided Anti-Defection Law, right? There are provisions under this law. Who has the power to decide on these disqualification matters? Speaker. But there is a bigger problem. The problem is there is no time limit within which the speaker or the chairperson has to decide these disqualification petitions. So the matter will go to the court and the court will take a lot of time to decide this matter. By that time, the term of these Rajya Sabha MPs would be over and then they will contest the elections again, and that time they will be formally contesting elections on the basis of the ticket given by the BJP. So just to violate the provisions of the constitution, the spirit of the law is getting diluted. What is your take on this matter? Should these MPs be disqualified? Should the law be amended? Or they did the right thing by resigning from the Aam Aadmi Party and merging with the BJP? Let me know in the comments. Thank you for watching.